Hi, welcome everyone to tonight's asset protection webinar. We're so delighted about the topic. We're really excited to have Bob Bloom, one of my great friends and mentors over the years, teaching for us tonight. It's been a long time since we've had Bob on our stage, and I'll introduce him a little bit later, but I'm really excited about this topic. As you know, this is for most of you, unless you're brand new, you've been around us a long time, you know that this is a long-standing webinar series, and we've had some tremendous speakers on. I was putting together this slide today and going, oh my gosh, there are so many people that we could put up on here. We've literally done hundreds of webinars over the years that we've been doing this. And to pick and choose from some of them and go, oh my gosh, we've had so much talent and so many great speakers, great attorneys teaching over the years. A lot of those videos are available on our YouTube channel. You'd go to YouTube, hit Protect Wealth Academy, and we rotate these occasionally. And so not everything that we've done is on there, but a whole bunch. And I think there's probably at least 200 hours of YouTube videos and things you could watch. We've got some great webinars coming up in the future. Mike Koval in a couple of weeks on teaching kids to trade. I'm going to talk, we did one about, Bob, you would have been interested in this one, how to protect retirement accounts. There are so many things that are not, so many accounts that are not covered by ERISA. And then the state laws get really weird, and how do you keep it from blowing up on the inside, and how to protect it from outside sources, and what are those threats? And that was a fun webinar to teach and to research. And anyway, so there's a whole bunch. We'll teach one here on how to avoid capital gains, and there we'll go through 10 or 12 different ways to avoid capital gains. We've got Josh Robertson and Preston Knight coming up soon. And so a lot to talk about. So stay tuned if you're brand new to us. And then we introduced here on Facebook a couple of months ago, some really good, we just keep adding little tax tips. And so, like us or connect with us on Facebook, and there's some really, I don't know, they're just short little blurbs about how to reduce taxes, and our goal is to get a couple hundred of these as well. And so pay attention to those. Those are always fun to create, and they tend to be getting some interest. And then, as you know, most of you know, we've got our big summit coming up next week, June 12th through 14th. This is a Monday, Tuesday, Wednesday class. We've got a great lineup. Michael Bowman will be back. We haven't had him on our stage for a long time. Mike and Stacy Acevedo, Scott Estel, Bill Danko, Pat James. We've got a great lineup for you next week. So if you haven't signed up for that, please do that. Or if or it's been a little while since you've attended, come back for a refresher course. There's so much that's ever changing in the asset protection world. The way we did things, the way Bob and I did things 20 years ago is not, oh my gosh. You remember, Bob, we were using a lot of irrevocable life insurance trusts, and we were using children's trusts, and almost exclusively family limited partnerships. And the estate planning exemption was at 675,000, then it went to 1 million and 1.5, and oh my gosh, so much has changed over the years. It's ever evolving. And so we stay very current at the summit, so we invite you to attend that. And then whenever we talk tax and legal, yes, there's going to be a disclaimer. So we can teach correct principles. Do they all apply to you? No, they're not. This would be a good time to meet with a professional and see how they work in your situation. And so we can't give investment advice. We can just teach correct principles and let you figure that out from here. So let me introduce you, Bob. When I started in this field in 1999. Bob was one of my great mentors. He worked with Jay Mitten directly. Jay was phasing out, Bob was coming in, and I could call Bob, and there were a few people, G.K. Mangelson and Dale West, and there were a few people that I could rely on, and Scott Estel and Scott Solberg, but these were my mentors, and this is where I learned asset protection. When I would write a book or a chapter, and I'd send it over to Bob, and Bob would take a little red pencil and he'd go, "No, you can't do that." He was such a great editor, such a great mentor. There's very few people in this industry I respect, partly because of their integrity, but Bob is one that he's just become such a good friend and such a good mentor. And I don't know anybody else I trust. This is a unique topic, and moving money back and forth in and out of the United States, and the legal structures are a little different in Canada than they are in any time we're going international. The tax rules are different, and Bob has taken this as a specialty, and everything he's known about asset protection, and he's taken this on as a specialty. We are so delighted to have you. This is a topic, I know it's a narrow niche, but we're going to be talking today about tax and legal strategies for cross-border and especially Canadian investors. Bob, my friend, so good to have you. Thank you for taking time to share your knowledge with our students. We appreciate it.
Thank you, Don. Yeah, pleasure to be with you, Don. And all the kind things you said, I can definitely say right back about you. So you've been a wonderful friend and a great integrity, and just have provided wonderful service and information to so many people over the years. So great job, Don.
All right, so you're going to be taking control of the screen now, is that right?
Okay, if we'd like to do that, let's see.
And will you be answering questions throughout, or would you rather people? Let's use the Q&A screen, not the chat screen. If you have questions, do you want to kind of hold their questions until the end, or how do you want to proceed, Bob?
Yeah, let's hold questions to the end. I don't think we'll go terribly long, so we ought to be able to answer questions at the end. So that'll be fine.
Great. All right, time's yours.
All right. Well, we're going to be talking, as you can tell, about asset protection for U.S. real estate investing, and we could also call this cross-border investing. And just a little bit to introduce this, if you are considering investing in the U.S., that would be what we call offense, because you're trying to make money in the U.S., and that's great. And everybody loves offense. I know it's a great part of the game. Yeah, take a look at this, my Canadian friends. Here we go. Let's take a look if we can get this to work.
Point shot in front, knocked away. A race for it, Nyquist. He's in the clear. He gets hooked. Right in. Couldn't bury it. Scores! He did it anyway. He still found a way. And it's 2-1.
Is something else. I tell you, Corey Perry from his knees is going to make this play. He walks right around to Hahn from his knees, gets the rebound, and those hands are something. What a play.
That is great stuff. You know, offense is the fun and exciting part of the game. Making money is great. So a lot of people make a big mistake after seeing something like that. And they say, well, that's exactly what I got to do. I just got to make more money and all my problems are going to be over. Well, you're smarter than that, because you know that offense is a very important part of the game, but offense is only half the game, because the other half of the game is defense. And take a look at this.
Short end, and it's almost in. Hunt swept it away. Did you see that? It was behind him going in, and he turned around and batted it away with his paddle. Unbelievable. One of the saves of the year.
The windmill spin the goal line. To Bryant straight, goes intentionally wide, right in front. No goal, no goal. Tuukka Rask made the puck disappear.
Rask again tracking the puck as the paddle down and grab the thinks he's got a sure goal. Denied.
Great stuff. So, if you are thinking about investing in U.S. real estate, you're playing offense. What I'll be talking about tonight is defense. So let's get started. And let me give you a little bit of background just about me. I've been a lawyer for a lot of years. I started out years ago in a major international law firm with 1,000 lawyers all over the world, and then went to an international oil company, which is now merged with British Petroleum. And for a number of years, I represented the world's largest airline, which was by far the funnest job ever. And I did all that as a trial lawyer, meaning that I sued people, I went to court, I defended clients as well in court as a trial lawyer. But one thing happened, one case changed everything for me and caused me to switch sides and become an asset protection attorney many years ago. So as an asset protection attorney, I've set up thousands of limited partnerships, corporations, and limited liability companies. And as Don mentioned, I work extensively with Canadians who are investing in U.S. real estate. So just to get started, I want to tell you a little bit about that case that changed my whole life. I was working, as I mentioned, in this large international law firm, and I was assigned a case that where I needed to defend a client whose name you would all know, and this client had done something wrong. They had fired some guys because of their age, and that is age discrimination. You can't do that. Now, nobody goes to jail for that. It's a civil penalty. So here I was defending this client who was just wrong, and they had done something wrong. The plaintiffs had a wonderful case. They had the facts on their side. They had the law on their side. Things were not going great in court. But here we were and doing the best we could. And all of a sudden, the plaintiff's lawyer made a serious mistake. And I capitalized on that mistake, and we ended up winning the case. So normally when you win, you are celebrating, you're notching another, thing in your gun belt, and it's a great thing. But this case was different because so often in court, it's one company suing another company, and somebody writes a check and life goes on. But this time, the plaintiffs were not just another company, they were people. And as I left the courtroom that day, I saw them weeping. The wives were saying, we're going to lose our house. We're never going to get another job at this income level. They'd lost their pensions, their salaries. They had lost everything. They were financially destroyed. And I was part of that. That was wrong. And I was part of that wrong. And at that point, I said, I'm not doing this anymore. I cannot do this anymore. I didn't go into law to hurt people. I went into law to help people. And so I took everything I knew about courtrooms, trial tactics, suing people, litigation, and I went 180 degrees the other way and became an asset protection lawyer many years ago. And that is so much more satisfying for me because now I can protect people from lawyers like I used to be. And asset protection is all about freedom. It's about freedom from fear. It's about financial security. And ultimately, asset protection is about peace of mind. So what I hope to present to you tonight is a way that you can invest in U.S. real estate and not be worried about litigation, not be worried about your liability potentially, not be worried about double taxation, because I will show you what works for Canadians who want to invest in U.S. real estate. All right, so we're going to be talking about cross-border real estate investing today. And for those of you who do business in Canada, of course, you would be using Canadian entities to do business in Canada. But likewise, if you're going to do business in the US, you would use US entities, not Canadian entities, to do business in the States. And you would use not only those U.S. entities to do business, but to own the U.S. assets and to protect your Canadian assets from U.S. liability. So because you're going to be using U.S. assets to invest in U.S. real estate, U.S. laws apply to those U.S. entities. And so I will be explaining the U.S. laws that apply to the entities that you'll use for U.S. real estate. All right. Now, there are a lot of different ways you could own real estate in the U.S. For instance, you could own real estate in your personal name if you want to, but it's a really bad idea because if you own assets, especially real estate, in your personal name, you will have what is called unlimited personal liability, which means it is unlimited. It is limited only by the amount of damages. That can wipe you out. So let's cross off owning assets in your personal name, because what that means is if you get sued in the US owning assets in your personal name, that liability reaches into Canada and can literally destroy not only your US assets, but Canadian assets as well. You could own assets in joint ownership, joint names, oftentimes joint tenancy is the way that's done. Same result. You will end up with potential liability to wipe out Canadian assets as well. You could do business as a general partnership if you wanted to, but the same thing happens. You end up with liability not only in the US, but extending into Canada and affecting your Canadian assets as well. You could use a limited liability company or an LLC, which we'll hear a lot about. That will help with liability, but the problem with an LLC is it will result in double taxation. And being taxed once is bad enough. Obviously, being taxed twice is far, far worse. And now we could also use what is called a limited partnership, or an LP for short. And that is the right tool, because a limited partnership provides not only lawsuit protection, and it eliminates double taxation. So these are the two reasons that we want to use a U.S. limited partnership, because no other entity, no other way of owning assets in the U.S. will accomplish both liability protection and elimination of double taxation. All right. This is what a limited partnership looks like. We have within the limited partnership, which is the blue circle, we also have a corporation, and I'll explain why in just a little bit. But I just wanted to give you a quick look at this. We're going to see this slide many, many different times. All right. Now, some very important basics are that Canadian residents are required to pay Canadian income taxes on worldwide income. The problem also, though, is that income earned in the U.S. by Canadian residents is subject to U.S. income taxes. So does anybody see a problem here? And that would be double taxation. So how are we going to eliminate double taxation with a limited partnership? Well, Canada and the U.S. have entered into a tax treaty under which a Canadian taxpayer is credited for any U.S. taxes paid. This is called a foreign tax credit. And the way it works is this. With a limited partnership in the U.S., the IRS says a limited partnership is what is called a pass-through entity. Now, a pass-through entity means if you picture a sieve and you pour water through a sieve, nothing sticks at the sieve level. It passes right through. And what that means is that income in a limited partnership passes through the limited partnership without taxation. In other words, the limited partnership as an entity does not pay taxes. The income in a limited partnership passes through and becomes personal income to you, on which you would pay personal income taxes. Now, that is the IRS's view. And the good news is that the CRA, Canada Revenue Agency, also views a limited partnership as a pass-through entity, also producing personal income. And the good news is, because we have personal income tax, I should say, being paid in the US, and personal taxes owed in Canada on the same income, now we have apples to apples. And we receive a foreign tax credit, because now the taxes we pay in the US will be credited against any taxes we owe in Canada. All right. So just to put some numbers to this, and these are completely made up and unrealistic. But if we had $100,000 of taxable income in the US, and let's make up a number and say you paid $20,000 of US income taxes on that, you would have to report the $100,000 earned in the US to the CRA, but you would receive a $20,000 credit against any taxes you would owe in Canada because that's what you've already paid in the US. That is the foreign tax credit, and that is what eliminates double taxation. All right. Now, you'll hear a lot about limited liability companies, LLCs. They're very, very popular in the US. And an LLC, unfortunately, will result in double taxation. So let me tell you why. It's because the IRS views an LLC the same way it views a limited partnership, and that is it's a pass-through entity on which you pay personal income taxes. The CRA says we don't agree. A limited liability company in the States is a corporation on which you would owe corporate taxes because it produces corporate income. The problem is we have apples to oranges. In other words, we're paying personal tax in the US, we owe corporate tax in Canada, and there is no offset under the tax treaty. In other words, it's got to be personal to personal in order to get a foreign tax credit. So in a case of using a limited liability company where you take income directly from the LLC, there would be no foreign tax credit, and that would result in double taxation. All right. So keep that in mind as we proceed, and hopefully that is a clear explanation. Now, obviously, the key to paying the lowest tax, not only in the US, but also in Canada, is to try to make your taxable income in the US as low as possible. And the way we do that is through tax deductions, which are very, very generous in the United States. Point is, you pay no tax on income that is deductible. Business expenses, for instance. And so there are many, many hundreds of deductions available for US corporations, and that will help to reduce the taxable income you owe in the US, and will also reduce the amount of taxable income you have to report to the CRA. We win big when we take tax deductions. So the point is, we can take many, many deductions in the US and pay very little in taxes as a result. All right. So one of the things we want to learn is, how do we reduce taxes? Well, the tool that does it perhaps better than any other one is called a C corporation. And a C corporation is going to be part of your limited partnership for reasons that I will explain in just a little bit. All right, but this is what the limited partnership looks like. Once again, on a diagram, there is just one C corporation. That's the two pink boxes are really supposed to be one and the same. In other words, I'm just trying to show you a little more detail in the top pink box. It is a C corporation, which serves as the general partner of the limited partnership. I'll explain a little more about that. But one thing that's important is, with a C corporation, there are some very important rules. And one of those is, we're never going to own real estate in a C corporation. We will manage real estate in a C corporation. Some other ways we can use this C corporation is we can use it to make offers. You'll see why in just a little bit. We can use it, once again, to manage the rental properties, whether that's long-term or short-term rentals. We can use it to lower taxes through deductions. And maybe most importantly, the C corporation will act as the general partner of your limited partnership. Now, I'd encourage you to take a screenshot of this screen, because you'll want to keep these rules in mind as to how we're going to use this C corporation. In other words, it's going to wear many different hats. It'll have different roles at different times. And so the C corporation is going to be a versatile and very useful type of entity to have in your toolbox, so to speak, for U.S. real estate investing. This is just another screen you might want to take a screenshot of. It shows you the business taxes that the states impose. And there are several states with 0 state income taxes on business income. These are very, very important. Once again, this is part of the tax picture that you're going to want to pay attention to. All right. So current U.S. tax law, now this is federal tax law we're talking about, allows real estate investors, which would be you, to be the big winners, because we can set up your entities as a pass-through entity once again, so you can qualify automatically for a 20% tax cut without having to spend any money whatsoever. Now, another type of entity allows for a 14% tax cut, and we set those entities up in such a way that takes advantage of those tax cuts. All right. So we use U.S. tax law to your advantage. So once again, we use pass-through entities in every opportunity that we can because of the 20% tax cut and to eliminate double taxation. All right. So the point is this. Taxes are complex in just one country. They become even more complex when we're talking about 2 different countries' tax regimes. So we must have a clearly thought out plan for your money. And to do that, I work very extensively with cross-border accountants to make sure that whatever diagram, whatever proposed structure we come up with that would fit your business, because this is all very individualized and customized, we make sure by running it by a cross-border accountant that we're going to be as tax efficient as possible. So when you have a plan for your money, you're saving lots of money in taxes, putting way more money in your pocket. But if you don't have a plan for your money, you know who does have a plan for your money, and you will not like that plan. All right? Now, that's all I want to say about taxes for the moment, because we need to talk about lawsuit protection coming up. But one more time, I just want to emphasize that the 2 very important reasons that we use a limited partnership is because it eliminates double taxation, which we just talked about, and it gives you excellent lawsuit protection, which we will now talk about. All right. So we're switching gears to discuss lawsuit protection. And here's just some statistics. The U.S. has 5% of the world population, and yet 94% of all lawsuits in the world are filed in the U.S. And that is a terrible statistic, and it speaks volumes about the U.S. legal system. In the Canadian legal system, you have what is called the loser pays rule, which is a wonderful rule that we do not have in the States. Which basically says, look, if you're going to bring a lawsuit in Canada as the plaintiff, the person suing, you darn well better have a fantastic case, because if you don't and you lose the case, you will pay not only your legal fees, but you will pay the other side's legal fees. That is the loser pays rule, which I'm sure you are very, very familiar with. In the US, we have just the opposite. We have not the loser pays rules. In fact, each party, each side, the plaintiff bears the plaintiff's legal fees, and the defendant has to bear their legal fees, win or lose. Doesn't matter. And in fact, what makes it even worse is the fact that we have in the US a very, very large contingent of contingency fee lawyers. Now, in Canada, you would call those injury lawyers. And that is similar to what we have in the US. So in other words, when somebody is injured in the US, either financially, they've lost money, they're angry, upset, or they're physically injured, they go to a lawyer and they tell their story, and the lawyer says, I'll take your case on a contingency fee basis, which means that the lawyer is basically going to invest in their case. The lawyer will pay all the legal fees, will not charge hundreds of dollars an hour for their time. The plaintiff pays nothing, and assuming they win, the lawyer will take about 50% of everything they collect. And so the lawyer gets paid contingent on winning. Now, think about what that means. That means that you, as a defendant, have a lot at stake. You're going to be tied up in the legal system in the US for 3, 4, or even 5 years. That is how long these cases take to resolve. During that time, you will be paying a lawyer hundreds and hundreds of dollars per hour just to defend yourself so you can keep what you already have. And if you win, most people who win a lawsuit feel like they still lost because of the amount of time it took from them, from their lives, the amount of stress they endured, and the amount of money they had to pay just to hang on to what they had. Terrible, terrible system. On the plaintiff side, if the plaintiff loses the case, they just walk away and they don't owe anybody a dime. So that is, unfortunately, the US legal system. All right. Now, because of that, lawyers really want to have a lot of cases coming their way so they can kind of pick and choose some of the best cases. So lawyers will go to the internet and actually put up websites to attract business. So here's one that says, canisue.com. Whocanisue.com. There's another, how to sue someone, how to sue a doctor. How's that? Or sue your landlord. 10 times you can sue your landlord. How's that? This guy could only think of 8 times you can sue a landlord and win. Here's another one, suing your landlord for mold-related health problems, and on and on and on. There are thousands and thousands of these websites put up by lawyers just to encourage more and more people to sue. Right now, we talked about the fact that when you're sued, you've got a lot at stake. You could not only lose the case, in which case you've paid lots of legal fees and you lost and you're going to have to pay even more. But if you win, you still had to pay the legal fees, which can be hundreds of thousands of dollars. The plaintiff doesn't pay anything, so they have no risk and there's no reason for the plaintiff not to sue. But the plaintiff's lawyer is the one who's taking the risk. And so plaintiffs' lawyers are not stupid. Very, very smart people. They are usually worth millions and millions of dollars. So before taking that kind of risk, before taking a case, plaintiffs' lawyers have the ability to go to the internet and do what is called an asset search. In other words, here is a typical assignment. Listen to what this says. This site provides detailed financial information to assist attorneys and clients in determining the economic viability of litigation, which means in plain English, how much money can we get from you if we sue and win? That's what they're trying to figure out with these asset searches. It goes on to say, we identify your bank accounts, your brokerage accounts, your real property, vehicles, watercraft, aircraft, business affiliations, and other valuable assets to satisfy judgments. So if you own it, we're living in a digital age, they will find it. Now, that's in over 200 countries of the world, and that does include Canada to the extent that privacy laws allow that information to be found. In the US, we have virtually no privacy laws, and everything is an open book. All right. So your US assets will be easily discoverable. Here's another site that for $85, they can find every property you own in the US, what you bought it, what you paid for it, and when you bought it. In addition, they can get a current address of your rental properties. And once they have your current address, they can now go to any number of free websites and find the government appraised value of your home. Now they don't, or your rental properties. Now they don't care what the government thinks your rental properties are worth. What they're trying to get at is how much equity do you have in these properties? Now, why would they want to know that? Well, because obviously, if they win the case, they can seize those properties and sell them off and put the equity in their pocket. And that's what this next site will give them. It includes a real property equity assessment because this is all public record. It's always been public record. So if you understood what I just told you, you will realize how vulnerable we can be in the US. Owning real estate, just going about our lives. There are so many other ways we can be sued besides just owning real estate. So I have a solution, and that is you want to definitely go forward. Don't be afraid. Go ahead and invest and become rich. You want to be rich, but when a plaintiff's lawyer does an asset search on you, you want to look flat broke. Now, why in the world would you want to look broke? Well, because when a plaintiff's lawyer does an asset search, they're going to spend maybe a minute looking at you online. And if you look broke, they're going to do some quick math and figure out that 50% of zero is zero. Well, and why would I waste my time suing a deadbeat if there's not going to be a payoff at the end of the day? And so if you look broke, there's a very good chance they're going to skip right over you and find someone better to sue. So how do we look broke? By not owning assets in our name, by not owning our real estate in our personal names. We want to own that real estate in an entity. And I'll show you those entities as we proceed. Now, one other problem with our US legal system is that you don't have to do anything wrong to be sued. Let me give you some examples. These are some actual cases. Red Bull's famous slogan, Red Bull gives you wings, got the company in some trouble. A class action lawsuit accused the company of having misleading ads and making false claims. The plaintiff said the energy drink did not give people wings, even figuratively speaking. That is, they didn't feel energized. They said the company lacked evidence to claim the beverage could improve one's focus, and Red Bull settled out of court and agreed to pay $640,000. Here's another actual case. Upon suing his newborn daughter, the dad said she was incredibly ugly and did not look like either parent. He accused his wife of cheating on him. His wife admitted she had had several plastic surgeries before they met. He sued her on the grounds of false pretenses, claiming she misled him by hiding her cosmetic history. He won the case, and his wife was made to pay him more than $120,000. That's a happy marriage. All right, well, here's another one. Two teenagers were trespassing on railroad property where they came across two live electrical wires and were severely burned. The plaintiff's lawyer conceded his clients were trespassers, but said the property owners were still responsible. I hope you're all sitting down, because a federal jury awarded them a total of $24.2 million. These are real cases. Here's another one attempting to leave a house that he had just burglarized. Terrence Dixon found that his escape route through the garage was a dead end as the garage door wouldn't open. And turning back, he tried to go back into the house, and he found out that the connecting door had locked behind him. He was forced to spend the next 8 days with only a case of Pepsi and a bag of dry dog food. Upon regaining his freedom from the garage, he filed a lawsuit against the homeowner's insurance company, alleging he had suffered mental anguish while he was trapped. And the jury awarded him $500,000 for his suffering. Wow. Well, here's a case that has not yet been decided. I think it's one of the most ridiculous cases I've seen. A woman is suing Kraft Heinz Company because she says Velveeta's microwavable mac and cheese cups are not ready in 3.5 minutes. The woman claims the time on the front of the package does not include other time-consuming steps, such as tearing off the lid. The lawsuit accuses the Kraft Heinz Company of fraud, false and misleading advertising, breach of express warranty, negligent misrepresentation, and unjust enrichment, along with violations of laws barring deceptive and unfair trade practices. There you go. It says it's ready in 3.5 minutes on the box, but she's saying, nope, not really ready. So she's suing. That's the climate. That's the culture in America today. Why not sue? There's no reason not to. You know, in other words, you might get some money from it. And, you know, if you don't, well, you just walk away. So why not? Well, we got to give them some reasons not to sue. And we're going to. Because let me just give you a few other ways that you don't have to do a darn thing wrong in America to get sued. You know, if you have employees, you can get sued because of your employees, because of what the employees do. They may have discriminated. They might sue you for wrongfully terminating them. Many other ways you can be sued because of what your employee has done wrong. If you own real estate, you can be sued because there's an injury on your property, as the general rule is that property owners have a duty to prevent harm on their property. Another way you get sued is because you own assets in joint ownership. I'll give you an actual case in just a little bit on joint ownership, how bad that can be. Handshake deals, in real estate, we partner a lot. I've got the deal, you've got the money. Great. Let's put it together. That's a general partnership. And you can now go broke for what your partner has done wrong. We want to form those partnerships with an entity, and I'll show you a way that you can joint venture, an actual diagram on that. You want to be careful about owning an asset because that's very dangerous when you own it in your name. Here's an example. Parents with teenagers who are learning to drive experience this. In the US, a teenager cannot own anything legally until they reach the age of 18, but they start driving at age 16. And so the car they start out driving is titled in mom and dad's name, typically. Well, son or daughter gets into an accident, and you know who gets sued? Yeah, mom and dad. But mom and dad aren't in the car. They weren't driving. They were at home minding their business. Why do mom and dad get sued? Because their name is on the title to the car. And the law in the US says, if you own the car, you control who you allowed to drive the car. And because you allowed a negligent driver to drive your car, the liable party is you. So you don't want to own assets in your name in the US. I'll show you how to own those assets in a minute. When you sign contracts, want to make sure that you sign them the right way. You may be signing letters of intent or joint venture agreements or non-disclosure agreements, lending agreements with a bank, purchase and sale agreements to buy the property, or you may be assigning the contract. All of these are contracts. And so the question is, how do you sign the contract? Well, you don't want to sign it like this. You don't want to sign your name as the buyer. Why not? Well, because that makes you a party to the contract, which means if the other side of the contract thinks you didn't fulfill the contract, they can now sue you for breach of contract. So instead, we want to make our corporation be the buyer. Remember, that's one of the ways that we're going to use this corporation. And yes, my name is on the contract, but as a representative of the real party to the contract, which is the C corporation. Signing this way with the C corporation as the buyer prevents you from being sued personally, which is exactly what we're trying to do. Now, by the way, if they want to sue the C corporation, that's bad enough, but let's get real. The C corporation doesn't own anything. So if they want to sue a company with no assets, go ahead. All right. Insurance may not cover you. Of course, you're going to want to have insurance, but the problem is insurance covers some things, but it doesn't cover mold or asbestos or pollution or contract disputes or employee actions or government lawsuits like the IRS coming after you, or lots of types of negligence. It certainly doesn't protect you against punitive damages. And somebody once said that insurance is a little bit like a hospital gown. You only think you're covered. So have insurance, but also have entities that will protect you in the event that the insurance is not there for you. Well, all these are ways you can be sued having done absolutely nothing wrong yourself. And the reason that you can be sued doing nothing wrong is because of a doctrine called vicarious liability, which basically says you are liable for other people's actions. And here's an example. Here's a real case. It was one of our clients said, my husband was involved in an auto accident that killed one man and injured another. The second man sustained injuries that cost over $1 million in medical bills. And she said, I was sued for everything I had. Now, she was a multi-millionaire as a real estate investor. She said, I hadn't done anything wrong except for owning a Lincoln Town Car in joint ownership. Remember, I warned you about joint ownership? She said, I was being sued for millions and my entire estate was at stake. The question I would ask is, does that seem fair to you? Doesn't to me. She's sitting at home, minding her own business. Her husband causes the harm and she gets sued. Well, I'll tell you the rest of this story in just a little bit. But the tool we want to use that will protect you from liability, from lawsuits in the US is called a family limited partnership, because that is our solution. We want to be rich and look broke. And the way we look broke is not to own assets in our name. It is to own those assets in your family limited partnership, which is also called a limited partnership for short. Now, limited partnerships are found in US law under Section 704 of the Internal Revenue Code. And in a limited partnership, there are two classes of partners. There are general partners and limited partners. Now, to analogize to a big Canadian company, let's consider, let's say TD Bank. All right. The general partner, which would be the pink box in this diagram, the general partner would be like the executives of TD Bank. In other words, they have signing authority for the bank. They make decisions on a daily basis about how to run the bank. In other words, they are the active members of the bank, so to speak. So in other words, that is what the general partner does in a limited partnership. It has signing authority for the limited partnership. It makes day-to-day decisions about how to operate the limited partnership. Now, limited partners in the limited partnership are like the shareholders of TD Bank. In other words, they own the limited partnership, they own the company, but they don't run the company. And that is also true. Limited partners do not run the limited partnership. They don't manage the limited partnership. That's the general partner's job. Now, because limited partners are passive, they have no personal liability whatsoever. So as a limited partner, you are protected from US liability. And that stops any kind of US liability from crossing the border to affect any assets you may have in Canada. Now, the general partner, though, because it does have managerial authority, also has liability for any debts of the limited partnership. So for that reason, we would not make you a general partner. That would expose you to liability. So instead, we create a corporation, which now is the general partner. Now you own and control the corporation. But that allows you to control the limited partnership by controlling the C corporation, which is the general partner, and yet you have no personal liability because you are shielded by the corporate form as the general partner. So you are officially the limited partner, typically owning 99% of the limited partnership as a limited partner. The general partner will typically own 1%, and that's all it needs to control the limited partnership itself. All right. So that is the best analogy I can give you, the difference between general and limited partners. Now, how does it actually work in practice? Well, I ran into a guy the other day and he said, I own 25 rental houses. What do you think of that? And I said, that is really good. I said, but how do you own them? And he said, well, just in my name. But he said, here's the problem. He said, last week, the police raided one of my homes. He said, it turned out that one of my renters was running a meth lab in the back bedroom. He said, if this dirtbag sold this junk to some kid and hurt a kid, could they sue me? And the answer is, you better believe they can sue him. And when they do, think about what they could potentially take. All 25 rental homes could take his home, could take his life savings, his vehicles. It could take everything he owned because he had, for a legal structure, all of his eggs in one basket. And that is the worst way we could ever be structured, because you're a sitting duck. You're an easy target for a lawsuit. None of your assets are protected like that. So let me give you rule number one, and I encourage you to write this down. And rule number one is never own investment real estate in your name. Let me repeat that. Never own investment real estate in your name. Instead, we want to own it in a family limited partnership. So the real estate is now owned in a limited partnership. And when you are sued, they cannot take the real estate in the limited partnership. All right. So very, very important tool. Now, here is the rest of that story. Remember the woman whose husband was out driving and he killed one man, injured another in a very serious accident. The second man was badly injured with $1 million in medical bills. And it was the wife who was sued. And she protested, I hadn't done anything wrong except her owning that car in joint ownership. And here she was being sued and her entire estate was at stake. Here's the rest of the story. She said, after the plaintiff's attorney received copies of my limited partnerships, I didn't have to pay them anything. Your structuring saved me over $3 million plus my entire real estate career. I will always be grateful. That is how powerful the limited partnership is in protecting you as a limited partner. Here's another case. Person said, after your talk, I got a family limited partnership. I later received some defective product from a supplier and refused to pay. The supplier sued me. He said, as soon as they found out my assets were protected, they dropped the suit and walked away. And that is exactly the main goal. And that is, we want to keep you out of the U.S. legal system by discouraging people from wanting to pursue a lawsuit by having you so well protected that they know they're not going to get anything. So why bother? Why bother to sue? And that is the real goal. All right. Another guy had a little different take on this. He said, excellent. I had no idea that I could protect my assets and screw a lawyer at the same time. All right. Well, how do we put all this together? We talked about taxes and avoiding double taxation. We talked about lawsuits and protecting ourselves from liability. Well, the way we do it is we start with a plan, a blueprint, if you will. It's an asset protection and tax reduction plan. Now, for someone who wants to invest in just one state, we would use a diagram similar to this. And you'll see that there are going to be different diagrams. In other words, let's say we're investing in Ohio, which is a fine state in which to invest. 0% business taxes, very business friendly. But beside that, it could be any state. In other words, in the U.S., we do not have what you have in Canada, which is a federal corporation, which allows you to do business across all provinces. We don't have that. They're all provincial in the U.S. In other words, if we're doing business, buying properties in Ohio, Ohio requires that we have an Ohio setup. In other words, Ohio entities to own those assets, to do business there. If you're doing business in Florida, buying properties in Florida, this would switch to a Florida limited partnership or a Florida corporation. So it will be state specific depending upon where the properties are. Now, once again, we have a corporation in the pink box as a general partner, and then we have typically you as a 99% limited partner. And in the case of investing in just one estate, the limited partnership itself would own the properties. All right. So your Ohio properties would be owned right in the Ohio limited partnership. Now, a minute ago, I said we don't want to use limited liability companies. So let me show you a diagram. And oh my goodness, we have limited liability companies. How did that happen? Well, this is for someone who says, I want to have the flexibility to scale my business into more than one state. In that case, we would have limited liability companies, which are owned 100% by the limited partnership. Now, the limited partnership, if you compare the previous diagram, it owned the properties. We've got the little houses in the blue circle, but now we don't. The houses, the real estate, is owned now by the limited liability companies, and the limited partnership has become a holding entity. And in this sense, a holding entity is simply an entity that owns other entities. In other words, the limited partnership owns the limited liability companies. Now, because you own another company, you would be entitled to the income from that company because you're the owner of that company. Well, the same thing is true here. The income generated by the rental properties in the LLCs belongs to the limited partnership because it owns the LLCs. And so all of the income flows from the LLCs into the limited partnership. You take your income from the limited partnership. That is what eliminates double taxation. By taking your income from the limited partnership, you receive the foreign tax credit, offsetting any taxes owed in Canada. Now, in other words, if you took income directly from an LLC, even on this diagram, you would be double taxed. So the key is to have that limited partnership always there. And that is the entity from which we take our income to eliminate double taxation. By the way, this structure also protects you that much better from any potential liability. All right. Now, there are many, many other things we could talk about on this diagram, but let me show you a few others very quickly. Remember, we have the single state diagram. Now we have the multi-state diagram. Now, people will sometimes say, well, what if I want to start with just a single state diagram, but then I change my mind and I want to scale into other states? Well, the problem with that approach is that now we have to duplicate the structure all over again. So in other words, if we want to go to Florida and start investing there after starting in Ohio, now we have to create a Florida corporation and a Florida limited partnership. Why? Well, because most states will require that the general partner entity also be set up in the same state as the limited partnership itself. And so it becomes more economical, easier, quicker to simply start with the multi-state structure if you want to scale, rather than changing our mind kind of midway through the investing. All right. So that's a question that I often receive. Why not just start with the first and then switch to the second? Well, we can't. And the reason, again, is we've already owned these properties now in the limited partnership. That disqualifies it from becoming a holding company. In other words, the holding company must never own real estate because that would allow the holding company to be sued. And if the holding company is sued, then what happens is you can lose the ownership of those LLCs and all the properties that those LLC owns. So we cannot own real estate in the limited partnership if we want it to become a holding entity. So we need to sort of decide right from the start, do we want to be able to scale our business? And many people are very clear about that. Yes, I do, or no, I don't. And then we have a clear idea of what approach we want to take. The whole idea is we want to get a clear plan before we start doing anything. Now, one other structure that people will often ask about is, I want to go big. I want to do big deals. I don't want to just buy single family homes. Maybe I want to buy multifamily. And to do that, maybe I want to have I want to bring on investors. I've got a lot of friends who may want to invest with me in my real estate in the States. In that case, we would have this exact same basic multi-state structure, but then we would add a limited partnership for our Canadian investors to become limited partners in that limited partnership. That green circle, as a new limited partnership, would own the multifamily property. In other words, it would hold title to that multifamily property. Your limited partnership, the blue circle, would own a piece of that as a limited partner. So maybe you own 25% of the green circle in your holding LP. That's what a holding LP does, is it owns shares of other entities. And then your investors might own the other 75% of that limited partnership that owns the multifamily property in the green circle. Now, remember, why do we use a limited partnership? Because if we have Canadian investors, we have to eliminate double taxation from them for them. And when your Canadian investors as limited partners derive income from the limited partnership, they eliminate double taxation. Now, on the other hand, If you're going to bring on US investors, well, we don't need a limited partnership for US investors because we're not worried about double taxation. So we would just use an LLC to hold title to the multifamily property. And as long as we have all US investors, that's fine. Your limited partnership still owns a piece of that LLC, and the US investors would own the rest as LLC members. So that is another structure. Another structure is this. People will sometimes say, look, I've got a friend. We do a lot of deals together, but we don't do every deal together. We want to buy together, in this case, maybe a 20-unit building in Texas. Okay, we're both Canadians, so we both have a basic structure, which is the limited partnership with a C corporation as a general partner. Maybe you're the one on the left, your friend, your co-investor is the one on the right. You're doing a joint venture. In other words, you're coming together with your limited partnerships, and together you are going to own percentages of this new limited partnership, which owns the 20-unit building in Texas. Now, assuming you have Canadian investors, they would own another piece of that Texas limited partnership. And yet these green circles are separate LLCs that allow you to go do deals without your joint venturer. So you have independence in doing that. All right. Now, another question I get is, what if I want to get a visa? An E2 visa is often a good visa to get. This would be a structure that we would use. And the SREI Inc. would be basically the entity that is an operating company that is the active U.S. company for qualifying for the visa. If you are interested in a visa, I work with a wonderful immigration attorney who is Canadian herself and has immigrated to the U.S. and lives in Florida now. So I can refer you over to that person as well. A question I also get is, well, I already have a Canadian company. Could I integrate that into the U.S.? And the question is not can you, it is should you? And the answer is, if we have what would be considered active income, that would be T4 income. Then yes, having a Canadian holding company integrated as the 99% limited partner in the holding LP, that would make sense, because now that active income goes directly to the Canadian holding company. You're taxed at about a 13% rate. If it's only rental income, that is passive income, and that would be taxed at a higher rate. And we would not then integrate a Canadian holding company if we only have rental income in the US. So as you can see, there are different structures for different situations, and all of these are customized and individualized. But the whole point of asset protection is to create roadblocks, to frustrate and discourage potential plaintiffs. In other words, we want to make it as difficult and as frustrating and as discouraging as possible from anybody coming after you with a lawsuit. So this is why we use layers. So in other words, we put the rental property into a limited liability company, and then we put that limited liability company inside of a holding LP. And once again, these are roadblocks. The more layers, the more roadblocks to discourage lawsuits. All right. And one side benefit, if you want to call it that, is the limited partnership avoids double taxation. You know, these structures I've shown you make the plaintiff's lawyer's job much more difficult, more time consuming, more expensive, more frustrating, because if they're going to come after you, we're going to make this a very difficult game for the plaintiff to play because you have such a good defense. And that is what we've got to keep in mind. In other words, you know, if you're going to play the game, you suit up for the game. You wouldn't go onto the ice, you know, against these pros without the gear, because you know what would happen. You'd get hurt. And so we don't go into U.S. real estate investing without having these protective structures to protect you from both double taxation and from liability as well. One of our clients said, my husband and I have 2 of your limited partnerships. We took them to our attorney and he said they were bulletproof. And indeed, we can become bulletproof by structuring ourselves properly. So we have a program called Legal Done For You. We are a legal team. And the way we start is we start with a consultation. So we have an appointment with you over the phone or Zoom, and we get to know what are your goals in investing in the US. Are you thinking of single family homes? If so, what states are you considering those? Would these be long-term rentals or short-term rentals? Are we considering something like maybe multifamily or commercial perhaps? And if so, would you be bringing on investors? And all these questions are very, very important to understand in order for us to give you recommendations, such as we would look at or draw a new diagram for you to show you what your particular legal structure would look like based on what you've told us, because your plans, your goals, your intent determines the legal structure. All right, not the other way around. We do provide discounted rates to set up entities, and that is very, very reasonable. So we do that for those of you who work with Protect Wealth Academy, and we're happy to provide that. And then we also counsel you, school you on, once you have these entities, what in the world do you do with them? How do you operate these U.S. entities to comply with U.S. law? So we send you this short article that we've put together on the do's and the don'ts. What you do, what you don't want to do once you have these entities in the US. Now, beyond that, we also guide you through the maze of red tape, because every state has additional requirements once you set up an entity in their state. For instance, you will have to have what's called an EIN, which is also called a taxpayer identification number. We get the EIN for you. We apply for that and handle that. You may need a business license, especially if you're doing short-term rentals or short-term Airbnb arbitrage. You may need a business license. We're aware of where you need them, and we'll help you with that. State tax registration. You will likely have to register with the State Department of Revenue, which is the state level CRA. You would need registered agents, and we arrange your registered agents for you. You will need to set up business bank accounts for each one of the entities. And people sometimes say, oh my goodness, why do I have to have a bank account for every one of these entities? Well, because these are real businesses. Show me a real business that doesn't have a bank account. We don't want these to be fake entities. They need to be real entities. We'll help you with IRS tax elections to the extent we need to. And there are some states that require that you publish the fact that you have created these entities. So there's a lot of red tape. We know exactly what each state requires. And people say, look, we would have been lost without your help. Thank you. I never could have figured this out on my own. And that's true. It would bog you down. So our job is to take care of the legal side of things. Your job is to go find great deals. And that's a good partnership. So as you invest in U.S. real estate, you are playing offense, and we've just shown you how to play defense as well. When you go into battle, you have a sword and a shield, because you wouldn't last very long without the shield. And people say, I think I get it. Offense and defense are just different sides of the same coin. If you're going to play the game, you got to have a defense. So with offense and defense together, you have more money because you're not being double taxed, and you are earning more money through U.S. real estate. And when you do, you have greater financial security. And when you have greater financial security, you finally have peace of mind. And you got to ask yourself, what is that worth? And most people would say that is priceless. Well, one of our clients said, the most important thing is knowing that my family is protected forever. And that is asset protection for U.S. real estate investing. So I'll turn it back over to Don and Kendall. And if we have a little bit of time, we might do some question and answers. Don, what do you think? Do we have any time?
So, yeah, let's take a few minutes and let's answer some questions. The one that keeps coming up is, what about if they're investing in other nations besides, or they're from I don't know, other places besides Canada? Can you help them with that? Is the legal structure the same, or is the taxes the same?
Well, no, it's not. The Canada and the U.S. have a unique tax treaty, which requires that we use the limited partnership to eliminate double taxation. That is not the case for many other countries. So we can use an LLC for people investing from most other countries. I've represented clients from Australia, the UK, Singapore, Japan, China, and Brazil, and other South American countries and Central American countries, and we have not found that we need to use the same type of structure that I just described for Canadians. This is unique to Canadians.
But you could help them figure that out in their situation.
By all means. Mm-hmm.
What if I own real estate, but it's covered in debt in Canada?
Well, we're talking about Canadian real estate that is encumbered. Is that right?
No, it looks like US real estate, but it's covered with debt.
Okay. Well, in other words, we don't have much equity in that US real estate. Is that what we're getting at?
Yes.
Okay. Well, if there's not much equity, there's not much to take. And so a plaintiff who takes the time to determine how much equity is in your properties, and if they find virtually none, because maybe you've done the Burr method, you've refinanced, you've stripped the equity, or you've gotten a HELOC of some kind, well, then that is an effective technique for protecting real estate. However, you're not going to want to do that in your personal name. You'll want to use that once again in conjunction with these entities we've talked about.
But even though, let's say I own a rental property in Florida with very little equity, and even though it may not be worth protecting because there's no equity, it could still cause liability for me personally.
Yes, it
could.
So
we still want that wall of protection around it, don't we?
Yeah. And equity is only one piece of the puzzle, because it may be cash flowing very nicely, even though it doesn't have much equity. And so we don't want to risk the cash flow either by having that property seized. We want to make sure that the property is protected in, once again, a limited partnership and using a holding entity as well.
Great. Okay. Alex is asking, in a multi-state structure, about the use of land trusts. Could the LLC be the beneficiary of the trust? And how do we incorporate land trusts in that, or is it even necessary?
Well, it's not always necessary by any means. We use often land trusts to achieve anonymity, and that's one of the purposes. There are several other reasons for using a land trust, but these entities generally allow us to, let me put it this way, we file these entities in such a way as to create anonymity. And so the anonymity reason for using a land trust goes away. We can use a limited liability company as a beneficiary of a land trust, but then we would want to make sure that we're avoiding double taxation. And once again, if we're taking income directly from a limited liability company, as a Canadian, there's a very high likelihood we will be double taxed.
Alex, I have students that have hundreds of properties that never use land trusts. A land trust is a very specialty tool that we'll use, especially like in Florida. If there's a due on sell clause on the mortgage company won't bend, we might use a land trust. But Bob, do you see real estate investors that use a land trust every single time, or is it a specialty tool?
It's a specialty tool. It's very rare that we would say you always do this or you always do that. And so it is a tool that's used in certain circumstances, but by no means is it always used, even in similar circumstances. It all is individualized depending upon the circumstances.
Yet I see promoters of land trusts use it every single time for every property, and if they're suggesting that, they're probably promoting and selling land trusts.
That's correct. And if the only tool you have is a hammer, everything looks like a nail.
Well, there you go. Okay. How about the structure with some property in Canada and some in single, and some in the US?
Well,
So you got one state in US, let's say Wisconsin, and they're also, or Michigan, and they're also owning property in Canada. How do we do that?
Yeah, that's very common because it's very often that our clients tend to be experienced real estate investors already in Canada, and they're just not finding the deals, the cap rates, the prices are too high in Canada. Markets are not favorable, and so they're looking south of the border and finding that the properties are half and the cash flow is twice. So it's very, very common for Canadians to already own real estate in Canada, and I assume I'm not trying to counsel anybody on law, but I assume you would be using either Canadian holding companies or other types of Canadian entities to own that real estate. And then we would, use the U.S. entities to own U.S. real estate and keep them separate. That's the key. We don't want to mix the two.
Cool. So if they wanted to consult with you and your law firm, how do they do? I think Kendall put in the chat screen a link. You'd simply go to protectwealth.com/Canada, and that would link you to Bob and his group. There you are. Thanks, Kendall. So protectwealth.com/Canada. There's no obligation. Nobody's twisting your arm, but that would give them a consult with you and your law firm?
Yeah, we'd be happy to consult at no cost for 30 to 60 minutes and find out if there's a way we can help you, find out what you're hoping to do in the US, and we would show you various possibilities of what you might want to do and see if any of those make sense to you. And if so, we'd be happy to go forward and help you with those.
Okay. Morgan is asking, she's saying she'd really appreciate the introduction to the immigration attorney. So Morgan, what I'd suggest is you go to the protectwealth.com/Canada, sign up for a consult and let them work with you directly. So that's the only way that I have of getting your information to Bob so he can get back with that. So Morgan, if you wouldn't mind, sign up for a consultation, and it might be 2 minutes, but that's our way of introducing you. Alex saying a C Corp is owned by my LP, which owns the LLC. Is that correct? So the C Corp owned by the LP would not be correct.
That's correct. You are right, Don. It would not be correct. The C Corp is not owned by the LP. The C Corp is owned by typically you as an individual. In other words, you're the shareholder of the C Corporation, and then you're also the officer, the president, vice president, and director of the company. So that would be a slight correction.
Yeah, so the C Corp, let's just say that the C Corp manages the LP, and it may own 1 or 2 or 10% a minority interest. So it manages, and then the LP actually owns the little single member LLCs that own the properties.
That's right.
Okay, got it. Okay. What reporting duties of the U.S. limited partnership and U.S. C Corp to the IRS and the CRA with respects to foreign nationals?
Well,
okay.
The limited partnership files an information return, does not pay taxes, but it still files a return called a Form 1065. Now, your cross-border accountant is going to know all of these things. So you don't want to try to be your own accountant or tax preparer on these matters. It's too complex. So you do want to have a good cross-border accountant. The C corporation will file a Form 1120, IRS Form 1120, and does pay tax, but it is de minimis, because even at $100,000 of taxable income, the C corporation is receiving 1% of that. That would be $1,000 and would pay $210 in tax to the federal government, the U.S. federal government. So we're not really concerned about taxation in the C corporation, but it does have to report and does have to file a return and pay taxes. Now, the limited liability companies, when they're owned 100% by the limited partnership, do not file a federal return in the U.S. They are considered disregarded entities. And so on that multi-state chart that I showed you with the purple circle in Florida and the orange circle in Ohio, with the C Corporation Limited Partnership, in other words, 4 entities on that diagram, only 2 tax returns would be required.
Yeah, great. And Abigail, what was the website again? It's protectwealth.com/Canada, and it's right there in your chat screen. Just click on that, and then that will take you to the consult thing. All right, so we got that. What would you recommend for structures if one has investments in another country, say UK, US people investing in other real countries' real estate? Is that a topic for a whole new webinar? Is that what we're?
Yeah, and it's really a topic to discuss with your UK attorney, because you would want, if you own real estate in the UK, you'd want to set up UK entities to own that real estate in the UK, which we don't do. I mean, we're not setting up entities in Canada, in UK, or any other country. We set up entities in the US for foreign investors who want to invest in the US.
Alma is asking, apparently no Canadian real estate with debt. Is that something that can be seen in the US as well? Yeah, you can own properties without debt. I don't see a problem with that.
Oh yeah, of course.
Yeah, you don't have to have debt.
No.
Alma, maybe I'm misreading your question, but you pay off the debt and have it free and clear, but the legal structure wouldn't change.
Mm-hmm. That's right.
You notice Bob didn't talk about how encumbered these properties are with debt. We simply, the legal structure doesn't change. Okay,
That's correct. You're right, Don.
Does the same legal structure apply in the US? If all your assets are in the US and your legal structures are, and you're a US citizen, do we do things, everything the same way you talked? No, it's altered a little bit.
Yeah, I mean, if you're a US citizen with no reporting requirements in Canada, now there are wrinkles to that. You could be a US citizen owning US real estate and you live in Canada. And if that, in that case, if you're a resident of Canada, then you are a tax resident of Canada and have reporting requirements to the CRA. If you are a US citizen and living in the US and have no connections to Canada, then you use an LLC, just like any other US resident would do.
And on that, Jonathan, attend one of our 3-day summits, and because that's what we talk about for 3 days. Anyway, maybe I misread your question as well, but I hope not. All right. Anthony, I have 5 LLCs right now. One of them in my holding companies, Wyoming, holds 2 intellectual properties. I know I have to separate them when I get some money, but does there have to be a special agreement with this? Also, Anthony, why don't you give me a call tomorrow and let me see if I can answer that question.
Mm-hmm.
Second question, also, what types of properties are good for investing for Canadian properties that are like condos that are cheap to buy? We can't give it investment advice.
Yeah, that would be a real estate coach who would discuss that with you.
Yeah, Anthony, you call me tomorrow. And you know the number. We've talked several times. So let's figure this out. How can you help Canadian protect Canadian assets if I arrive? Oh my gosh, I can't talk tonight, Bob. How can you protect Canadian assets if I reside in the U.S. as a U.S. resident?
Well, you would use Canadian entities set up in Canada to protect those Canadian entities. And then to the extent that you have potential liability in the US, you would want to limit that liability by using these limited liability entities so that any potential liability that you might have in the US does not affect any of your Canadian assets. So you want to think through how do you own the Canadian assets? If they're owned in your personal name, that is probably, there could probably be an improved structure by talking to a Canadian lawyer.
Let's say you had a US LLC or Wyoming LLC. Could that own Canadian entities?
It could own Canadian entities, but is this the same question? Is the same questioner?
Yes, same
Okay.
question.
The U.S. Resident and citizen owning properties in
Yes.
Canada. Yes, a Wyoming holding company could own a Canadian company, just like a U.S. entity can be owned by a Canadian company. That was one of the diagrams I showed.
Yes, perfect. Hi, Bob. Would you recommend the same LP with a C Corp setup with international real estate, where the international real estate is held in international companies that would be owned by the US LP?
Well, yes. I mean, the short answer is yes, that can be done. The question is, we'd need to know a lot more facts about whether that's an optimal structure or not. I mean, it certainly could be done. The big question is that the right structure?
Yeah.
I don't know the
so
answer to that because we need to
initials
know a lot more.
AP. I think AP, that must stand for asset protection. That'd be a good time for a personal consult to see. You mentioned international real estate in international companies, and we need to know a little bit more specifics of what countries we're dealing with. And
Right.
yeah, so schedule that consult again, protectwealth.com/Canada, or click on the link. And it's too vague a question. All right, is the holding LP a separate incorporated entity or established by contract?
It's a separate incorporated entity and not established by contract.
Okay, there we go. Good, thank you. Do you recommend X-Broader accountants?
Do I recommend what?
X-Border.
Cross-border, yeah, that X would be cross. Yes, I do recommend.
It's really late here. I'm sorry.
True. Yeah, I do recommend. I mean, if somebody is a Canadian tax resident investing in the US, then I strongly recommend that you use what is considered a cross-border accountant. There are loads of them in Toronto, loads of them in Florida, and lots of other places where Canadians love to winter. I work with a number of them and think very highly of the ones I work with.
And somebody, I think this is a repeat question, sort of. Then do you recommend always taking the equity out rather than paying down the mortgage? And that is the $100 million question.
Yeah, yeah, that's an individual decision.
Some investors really want a lumpy pillow with lots of cash in it. Some people want their mortgages paid off. But does that create more risk inside of an entity? Yes, it does. You're right, Bob. That's an individual decision. I don't know how to answer that.
There's no answer because it's completely subjective.
There we go. Judith, what would be the best legal structure if one is a US member and the other is Australian? Is this you've got two partners, two members of the same entity, or I guess that's what we're doing. One's US, one's Australian.
Well,
Any
we don't
ideas?
have a Canadian involved in that mix, and so we're not concerned about CRA jurisdiction, double taxation. So we can typically use a limited liability company in a situation like that, where both the individuals are members of the LLC.
Would the Australian need an ITIN number to be able to
Oh, yeah.
do that?
Oh, yeah. Anybody who's going to receive income in the US will need an ITIN, which stands for Individual Taxpayer Identification Number. That's the equivalent of a social security number for someone who's not a citizen or doesn't have a social security number. But it's the number that the IRS would use to identify you as an individual, just like our social security numbers are used in that way for US citizens.
All right, Bob. Woohoo. You knocked down all the questions. I hope this has been very, very helpful. It's been very enlightening for me. So Bob, we appreciate you being here. Any closing comments before you leave?
No, I just think that what we're finding is the US is a very receptive area, very good country in which to invest at the moment. Markets change, circumstances change, but lots of Canadians are finding very good investments in the US. And so, this is a topic that requires a legal structure. If you're going to invest in the US, suit up for the game
and do it right.
Yeah.
Do it in a way that doesn't, you don't get killed in taxes, you don't expose yourself and your home and your family and everything else you own to an action, whether it's in the United States or not.
Right.
In US, we've kind of learned to live with it, but for outside investors coming in, they're looking at our legal structures and our lawsuits, and they laugh at us and they're going, "Are you kidding me?" Well, we maybe we become too hard-skinned looking at this. Bob, we appreciate your expertise. Thank you for being on. I appreciate your friendship over the years.
Likewise.
Students, now would be a good time if you're interested at all. It's a free consult. I mean, don't waste their time. But if you're from Canada, you live there, you invest there, take an opportunity to meet with one of the best law firms in the nation. Certainly somebody that we trust and admire over the years. Thank you, Bob, for being on.
You bet, Don. Thank you.
All right. And everyone, have a great night. Thanks for being here. Bye-bye.
Likewise. Bye-bye.